Ethical Perspectives on the News is produced by the Interreligious Council of Lynn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Good morning and welcome to Ethical Perspectives on the News. My name is Scott Samuelson and I'm a professor of philosophy at Kirkwood Community College on the Iowa City campus. The vacancy on the Supreme Court after the death of Antonin Scalia has thrown the political world for a loop. It's been almost 80 days now that the Supreme Court has been one member short, and it's been almost 50 days since President Obama nominated Merrick Garland for the position. Senate Republicans argue that it's inappropriate to conduct hearings in the midst of a controversial election year. They think that the American people should decide who they want the next president to be and, by extension, what the next Supreme Court justice should be like. But many believe that the Senate is simply failing to do its job by refusing even to consider a person many consider to be a well-qualified moderate nominee. The question should be when and how to hold hearings, not if to hold them at all. Does Merrick Garland deserve hearings? Or does precedent suggest that a nomination should wait until after a new president has been inaugurated? Behind this controversy is an even bigger issue. What's the relationship between politics and the court? To what extent should elections determine who's on the court? Should we expect justices to carry out the will of their political party? How should the court be insulated from the political realm? We have a great panel on today to discuss these issues. To my left is Todd Pettis, a professor of law at the University of Iowa. Thanks for being on, Todd.
Thanks for the invitation.
Laura Kaqmienski, an attorney and also a member of the Lynn County Republican Central Committee and 5 Seasons Republican Women. Laura, thank you for being on. And at the end, Tim Hagle, an associate professor of political science, also at the University of Iowa. Thanks for being on. Okay, well, maybe, Todd, let's start with you. Are the Republicans in the Senate failing to do their job by not holding hearings for Merrick Garland?
Well, insofar as what the Constitution says about what their job is, the president nominates someone to be on the court, and then it's the job of the Senate to provide advice and consent. That's their role. Okay. Now, there's nothing in the text of the Constitution that says that when deciding whether to give consent, they have to proceed in a certain form. And so, my own view is that as a constitutional matter, to say that they're not doing their job or that they're somehow violating the Constitution by doing what they're doing, that's not my view. So I might have a political view that it'd be better to go ahead and have an up or down vote than not, but I don't think one can say that they are violating the Constitution by refusing to hold a hearing.
Right, so we could sort of say there's 2 ways we could ask the question. One is, are they doing their job by the letter, technically speaking? Are they in violation of the Constitution by refusing to hold hearings? But we could also ask the question, sort of like maybe they're not in violation of the Constitution, but is this what they should be doing? I mean, some people say it's a kind of a moral issue that they ought to do what the Constitution asks them to do, even if they technically can get away with not doing it. Perhaps they should be giving this guy a fair shot.
Yeah, their constitutional job is to decide whether to approve a nomination, and they have chosen not to approve not only this nomination, but that any nomination that will come from this president. So in that sense, they're doing their job. Whether they're doing their job to the satisfaction of the American people depends on whether they choose to hold senators accountable for the negative or for the positive. Perhaps voters will be thrilled about how the Senate Republicans are handling this. Perhaps they'll be greatly dismayed, and we'll take that into account when these senators stand for re-election.
Okay, well, I want to come back to some of those points because I think those are worth revisiting, but let's bring Laura in on this. I mean, so should the Senate hold hearings for Merrick Garland, or is it appropriate to wait until the election and see what people want the next Supreme Court justice to look like, or what they want at least the nominator of the Supreme Court justice to look like?
I think it's totally legitimate for them to be holding off on this. As the professor said, their job is advice and consent, and they advised the president, we think you should wait and let the next president make the appointment. He, as is his prerogative, chose to ignore that advice and make the nomination. There are no hard and fast rules about how fast they must have hearings, and I think, at least politically, there are plenty of people who want to wait and have the next president, even Democrats who want to wait and have the next president make this nomination.
But what do you say though to the voter who says, look, I voted for Obama. One of the reasons I voted for Obama was I wanted someone to nominate the next Supreme Court justices. And I thought I got 4 years of that as a possibility. And you're telling me, no, people can say, oh, you know what, we're going to wait until we get another president to do this?
I think that's
he
an
has
argument.
3 years of nominating Supreme Court justices, but not 4 years on his term?
Well, when George W. Bush was nominated to his second term, he got 2 years before the Democrats started saying, okay, nobody else now. We have to wait for the next president.
I mean, what should we, 1 year? Would that be?
Fair. Didn't your mom tell you growing up, life's not fair? That's
Well, I
kind
know,
of
but I thought we had politics to correct for those unfairnesses.
we have politics to correct for unfairness, not courts.
Yeah.
Courts, and again, this is kind of the argument behind the nomination about just how active we want the court to be in settling fairness and
Right.
those
Yeah,
kinds
and
of disputes.
I think that is an issue that we also need to revisit. But let's also get Tim in on this. So, I mean, what do you see the job of the Senate when it comes to Supreme Court nominees? Are they living up to what we expect the process to be, or is this somehow a failure on their part?
I'm glad you asked that question, because just today I was reading a very long speech that then Senator Joe Biden, head of the then Senate Judiciary Committee, gave on the floor of the Senate. It was in the congressional record. And actually part of the speech was, this was in 1992, during George H.W. Bush's fourth year. And he was even quoting a speech that he had given in 1987, talking about the history of this. And apparently, according to Joe Biden's research, that the founders really wanted the legislature, Congress, to appoint all the justices on the Supreme Court, but the lower federal courts as well. And that didn't pass, and they went back and forth, and eventually they reached the compromise where it would be the president that would nominate, and the Senate would have its role to approve with the advice and consent of the Senate. And as was indicated, the Senate has given its advice this time, and it's not the first time. There have been a number of examples, some of them rather old, of election years when the Senate has chosen to say, well, let's wait and let the people make another decision, because they're going to have a choice for the next president potentially, especially in a situation this time where you don't have the current president, President Obama, running for re-election again, unlike, say, in 1992, where George H.W. Bush was in fact looking to run for re-election again, and Biden was saying, well, let's wait until after the election to see whether they would allow any of Bush's nominees to go forward. Now, at that time, they didn't have a Supreme Court nomination to deal with. And Biden currently has said that, well, look, every time when I was the chair of the Senate Judiciary Committee, every person got a hearing, got a vote. Well, sure, but they didn't have a situation where a Supreme Court nominee came up in an election year. And the most recent time that happened was in 1968, when Chief Justice Earl Warren decided to retire so that his friend Lyndon Baines Johnson, or so Johnson, not so much his friend, but so Johnson could make the appointment. And it went badly, and politics got involved, and that's one reason why justices don't like to retire in election years. One other quick thing on this, you mentioned about how, well, they voted for Obama. Well, though a lot of people also voted for Republican control of the Senate in 2014.
Right. So you're saying you think history really is on the side of the people saying the Senate doesn't really have to act right now, and in fact, maybe by putting it off, they are doing their job, that they're doing what is expected of Senates, at least historically speaking.
Sure, I'm not a big fan of that history on the side of one thing or another. History is history, its facts are facts. But there are examples in the past of situations where the Senate or senators have spoken out against the possibility of approving the nominee of a president in an election year, when again the people get to make that choice. And it would certainly be an interesting thing for the next president, whoever it may be, to have that particular gift, or however you want to phrase it, upon coming into office, have one nomination to the Supreme Court right away. That's a very important thing to have.
But I guess, I wonder if there's a distinction, and really anyone can weigh in on this, between, I mean, on the one hand, I really get why a senator would, or even a group of senators would, in an election year or within some period near an election, would say, I'm not so sure we should hold hearings. Maybe we should wait till after the election, as a kind of bluff, and in which to say to the president non-verbally, we really want you to nominate a kind of a moderate here, and then maybe we'll do it. But if you push us too far, we might back off altogether. In other words, part of a kind of gamesmanship. I don't know, like Biden in his speeches. Was he, willing to go all the way or not, or was this part of the kind of political game that was being played? You think of Kennedy was nominated in about a year out from an election, and the Democrats did go through with approving them, though I'm sure that some spoke out, that maybe we shouldn't do this at all at that time.
Let me jump in on that, because I've got kind of a theory on this. I had done some studies on retirements from the Supreme Court, and the first year of a president's second term is usually a good year for any Supreme Court justices thinking about retiring, again, if they've got sort of a political angle to it. So 2005 would have been a really good year for a couple of the justices to retire, but it was also at that time when the Democrats, even though still a minority in the Senate, started holding up a number of George W. Bush's nominations to the courts of appeals. And in a sense, this was a signal to any justices contemplating retirement that if you decide to retire, we're very likely going to try to hold up the nomination. And I think that that was one reason why you didn't see a couple of the justices retire in that later year.
Right.
Well, if you want to talk about politics and the gamesmanship in the Senate, Senator Grassley, the chairman of the Senate Judiciary Committee, just received an award from the ABA, the American Bar Association, for the work that he's done to compromise and get some Court of Appeals judges appointed and approved. So I think that was probably a very awkward event at the ABA a couple weeks ago, given that the Garland nomination had just come through and the Senate had said, yep, no hearings on this one. But they have been working to, especially the lower court judges, get a lot of those approved.
Yeah. Well, I guess I'm asking in particular is because this doesn't seem to me entirely just a hypothetical question. I mean, it seems like Obama understood that the Republicans were likely to bail, so he chooses a nominee that many Republicans have signaled that they are supportive of and is the kind of person that they could accept from a Democratic president, and yet still there is no action on it. So I guess to me, this seems to me, taking it to another level here, and I'm wondering if that's not why a lot of people are really angry about this.
This is speculation on my part, but if within 20, just in kind of a fantasy world, if within 24 or 48 hours of when Justice Scalia died, and I'm not suggesting President Obama should have done this, it's utterly unrealistic, but just as a thought experiment, if President Obama had said, I'm going to nominate Merrick Garland to be the replacement, I suspect that the Republicans would not have taken the position that they have now. I doubt very much that they would say, no matter Garland, whoever you nominate, we're absolutely not going to hold hearings. The voters need to have a chance to speak. Let's wait until the fall. Because Judge Garland, he's currently on the D.C. Circuit, a very respected judge on a very respected court. He is widely regarded, both on the left and the right, as a very solid judge. And I think with all the caveats that come with our polarized political world, he would be a safe nominee in any other year, any other circumstance. But we didn't get the Garland nomination until after certain important Republican leaders had said, absolutely not, no matter who he gives us, we will not hold hearings. Right. Well, then they get Garland. At that point, they put themselves in a position, taken a position, and given that position a rationale about the voters needing to have a chance. So there's a lot to backtrack from. Right. I think they were fearing that we were going to get a judge who patently was going to swing the court to the left, and I don't think Judge Garland is one of those judges, but that's what they feared, and so they sent up this strong signal that we're going to wait for the voters. And so we get Judge Garland, and if kind of worst case scenario for the Republicans, if the Democrats win the White House, and especially if they win control of the Senate, Judge Garland, in hindsight, is going to look like a pretty darn good Supreme Court justice, I think.
And it's very possible that if that happens, that they can quickly approve Judge Garland.
Well, all it would take would be for President Obama, seeing that election outcome, to withdraw the nomination.
He said he would not do so.
Well, yeah, politicians say all kinds of things, but if you get the Senate back and Hillary Clinton or whoever the nominee is wins, that may well change. I mean, candidate Obama said some things about accepting public financing or not. I mean, politicians change as time goes on.
You also have the political issue then of if it is President Hillary Clinton coming in, maybe some egos. We hear plenty of stories about no love being lost between the Obamas and the Clintons of him making sure she doesn't get to make his appointment.
Right. Well, but what? Okay, so I want to revisit an issue that Laura, maybe you can speak to this first. You were giving me at least the impression that you think of this as being pretty much politics as usual, that if the shoe was on the other foot, it would be the exact same story, and maybe has been the exact same story in the past, that this doesn't represent a breakdown of the Senate. This is Senate's doing what they always do, and if it's a Republican, the Democrats oppose. If it's a Democrat, the Republicans oppose. Do you think that's a fair characterization of the situation?
I think so, yeah. If you go back to 1795 was the first Supreme Court nominee who was not approved, and that was, President Washington, who was warning us against political parties, and his nominee didn't get approved. The last time this, well, of course, talk about '89 with Kennedy, and the very polarizing nominee who he replaced, Bork, who's now a verb, if you want to think about that. I believe it was 1954, President Eisenhower had nominated a judge to be elevated to justice who was not approved, and then after the elections that fall, he renominated the same nominee, and he was approved by the Senate.
But so, and is the historical sense also that the outcry is always the same as it is right now? I mean, it seems like Grassley's getting constant barrage of calls saying, do your job, as the Senate is more generally. Is that also, I guess what I'm wondering is that it seems like there is a perception among people that I guess seems somewhat accurate that this has been a fairly obstructionist Senate and Congress, and that this is just one more example of them not doing anything to advance the political process, but rather to impede the political process.
Well, one party's obstructionist is another party's, thank goodness for not making things worse.
Right.
So that's what you try to do. It's a political season, it's an election year, and again, that's why a lot of times the justices don't want to retire in an election year, because they don't want this to become part of that electoral process. And in fact, that's what then Senator Joe Biden was arguing about, saying, look, let's wait until this political season is over before we engage in the serious business of trying to determine who should sit on, in this particular case, the Supreme Court, or to that extent, in terms of lower courts, it doesn't get the attention, so that process can continue. But at the Supreme Court level, it's become so important and so polarizing that to then make it on top of that the election season, it makes it even worse. And that's what we're seeing. And I don't know that people are necessarily thinking they're really going to throw Grassley out, but at the very least they're going to make it a more difficult election for him, and resources that might have gone to other states will have to come into Iowa to make sure that he doesn't get unreelected. Not a good word, but basically that he's not thrown out of office.
Right. Well, let's get to this, to me, what I consider even a sort of larger issue, about politics and the judiciary together. I mean, to what extent should the appointment of justices be a political issue in an election? Is that appropriate that we think in those terms or not? I mean, maybe we can start with you, Todd.
I think it's absolutely appropriate, at least up to a point. In fact, I've always wished, maybe it's just because I've entered the legal profession, I've always wished that in presidential elections it was more of an issue. What kind of a candidate is this person going to, what kind of nominee is this person going to put forward? What kind of nominee is that person going to put forward? That's one of the consequences of presidential elections. It's an absolutely appropriate consequence. The Constitution tells us that this is going to be a consequence, and it would be foolish and just absolutely putting the blinders on to say that we should pay no attention to what a presidential candidate's judicial nominees are going to be. So they're unavoidably political in that sense. It's also unavoidably political in the sense that the court decides a lot of questions in which people have differing political views. Citizens United being a recent famous example having to do with the political world itself, but or talking about same-sex marriage. They hand down decisions about which there is political disagreement. And so in terms of how they get their jobs and then what the nature of those jobs are, there's politics all over that.
Right.
One other thing to be said about this in defense of judges, because one might draw from that the inference that the judges themselves are just politicians, they're just political actors. And I honestly don't think that any of the 9 or now 8 Supreme Court justices see themselves that way. I don't think that's their self-understanding, for whatever that's worth. And I don't think most federal judges on the lower courts understand themselves that way. But they do have different worldviews. The Constitution is a short document. For all the things that it touches, it's a very short document. And people in good faith can have different judicial philosophies, different interpretive methodologies, different starting premises that are going to lead them in different directions. And I think that they can hold those views and they can have disagreements with one another and still be judges for the most part, and not just mere politicians doing what they personally prefer or what they think is going to please a large segment of the public.
Right, and I appreciate your kind of balanced perspective here of the one hand political views matter, on the other hand a judge does something that transcends mere politics, or at least one hopes. But I take it that if we think of someone like Scalia, whose vacancy is causing the problems right now, that he, at least at times, seemed to talk as if a judge really should be completely above politics, that a judge should be like a referee whose political views are completely irrelevant to whatever is and that ideally you just call it like it, call balls and strikes based on the Constitution, and that politics shouldn't play a role at all, and that insofar as they do, this is just legislation from the bench, this is just, a few people being given more power than they really deserve. And it seems like by turning if that view has anything to it, it seems that by turning it over to the electorate, you're just making the problem worse. You're just sort of saying, hey, we're going to elect someone who's going to push, my politics on the bench versus someone else's politics. Is that a problem or no?
Not to get too deep into the sports metaphor here, but I usually like to see judges as referees, not umpires.
Okay.
Because the umpire, like you said, is calling balls and strikes, calling people safe and out. It's more an active part of the game, where you see as the referee more someone who, I'm only going to tell you when you do something wrong, a foul, a bad hit, whatever it happens to be. And so in that sense, judges have that view, and I think it's a good way to put it in terms of that they have a worldview. And I don't know if they're necessarily deluding themselves in the sense that you really are political and sort of have this view that goes with it. But I think also, too, that they do strive in many instances to try to be objective in their approach. And that's good. And let's keep in mind, too, that when we're talking about justices like Scalia, who is known to be a conservative, or you talk about the liberals on the court like Ginsburg and so forth, they don't always vote that way. And we were talking before the show started about a couple of justices that maybe voted contrary to their opinion. But the example that I like to always use in my classes involves Scalia and the famous Texas versus Johnson flag burning case, where oddly enough, it was Scalia who stood with the First Amendment free speech and said that flag burning was in fact protected speech. And Justice Stevens, who was a liberal at the time, joined the conservatives and said, yeah, I agree with free speech, but the flag is special. So they don't always vote the way we expect them to, but you have to find what issue it is that they're sort of going away from, either a conservative ideology or a liberal ideology.
Well, I think that, again, that seems right and maybe even hopeful at some level. But, Laura, is it a problem that right now 4-4 ties seem to be a common occurrence without Scalia on it, and that it seems like who's ever nominated is going to be breaking these kinds of 4-4 ties, and that you basically have 4 people going to vote one way and 4 going to vote the other? And in fact, maybe it's even a little more complicated with Kennedy, but that you have liberals, conservatives, the liberals pretty much, okay, there's some exceptions, but pretty much go always with the liberal view. The conservatives pretty much always go with the views you associate with the Republicans, and that this is just sort of a very special form of legislation going on at a very high level, and so we're going to vote the person in who's going to be doing that kind of, rather than have 100 people in the Senate, we're going to have 9 people on a court who are deciding things.
You're killing me.
So the fact that you're calling judicial decisions a special kind of legislation is making the conservative attorney in me, my blood pressure shoot through the roof. That You know, judges are not supposed to be legislating. That's why we have the House and the Senate. They're the ones who are supposed to be.
But I take it
are
they're accused of
supposed to be
legislating all the time, including
have
by
empathy.
conservatives.
Right, and, you know, I think that's one thing that, say what you will about Justice Scalia and whether or not you agreed with him, he had a very clear, well-developed theory of judicial interpretation that he was very consistent in sticking with. That's why you got cases like the Texas case where he said, free speech.
Right.
As much as I may not like it, yeah, you can burn the flag.
Right.
And I think that's one thing that at least I, as a conservative, would look for, is having that clear theory of interpretation that we know how you're going to approach every case.
Well, but doesn't Merrick Garland have, I mean, he seems like a pretty straight shooter on this score. I mean, he's not an originalist, but it seems like he's a fairly even-handed justice, and he's not someone who seems to be a legislator from the bench, but someone who looks at the merits of the case pretty clearly and rules in good conscience about it, and has a long proven record of that. I mean, is he a good nominee in that regard?
I think at any other time, he, you know, if he were coming through in the first term or first year of Obama's second term, yeah, he'd probably be a shoo-in for confirmation. But that's not where we are right now.
Republicans are hoping for more.
Right, but you're saying they might get less.
They might get less. They might get more.
Right.
They might get Garland.
Well, so...
But can I just respond?
Please, yeah.
Just very briefly, because I know time is short. 5-4 ideological splits are not the norm. They're the exception.
Okay.
The great majority of the Supreme Court's cases are decided by voting patterns and votes that are not 5-4. There's much greater agreement that splits across ideological boundaries. There are some 5-4 splits, and they tend to be in high-profile cases, so they get a lot of attention. That's one. Number two, we have not had a lot of 4-4 decisions since Justice Scalia's death. We've had a few. We've had a small number. One having to do with unions and speech, a big issue. That issue will be back to the court. And I think the justices, and we'll see a few more 4-4 splits, I'm sure, but I think the justices themselves are very likely to work very hard to minimize the importance of this ninth appointment. In other words, to show that if agreement can be found, if compromise can be found, they're going to find it. It is not in their interest to kind of play this up that, yes, we need the ninth vote to come in because we're just irrevocably divided from one another. As an 8-8 court, I think they want to show that they can function very effectively as an 8-8 court.
Well, and so Tim, just quickly too, what do you see as the qualities of a good justice, and to what extent should we consider politics or their political views and we're thinking through these issues?
It's hard to separate the judicial philosophy these days from the politics. Again, we'd like to see, at least to a certain extent, that overt politics is not part of it. And even in terms of the judicial philosophy, you're going to get a big disagreement from the right and the left as far as what's appropriate. Do you look to just interpret the Constitution and the laws, just read what's there as much as possible, and not, as the phrase goes, legislate from the bench? Or do you want someone who has a more expansive view and will read into the Constitution? Things like determining a new right, like talking about the right of privacy that was recognized. People complain, well, it's not in the Constitution, but we know from the Ninth Amendment that there are other rights out there, and the court decided this was one of them. Do you want that kind of legislating from the bench, a more expansive view, or not? And that's really what the senators have to bring it back to them. They have to determine in terms of looking at a nominee's judicial philosophy. Okay, well, I'm afraid we're out of time, so we have to wrap it up. But I'd like to thank you guys all for a really stimulating discussion, and I hope it's one that is continued in your homes and communities. So thank you very much, and we will see you next time on Ethical Perspectives on the News.